Wait, Lordship, I like to mention item number 24. This matter was already listed on the previous date for mediation, which has been, there is an order that we have denied. It is wrongly listed.
Item,
24.
what do you want?
Mediation has already been done, and we have denied any mediation.
Okay.
It may be come for regular listing.
Mr. K. Saxena. And counsel for the petition of submitted earlier, this matter was referred to the special mediation drive, mediation formation. However, the mediation failed. Therefore, praise for listing this matter for decision by this court. So it's at what stage? What stage?
It's admission.
Admission. Okay. The other side is present.
Yes, I have already spoken to him.
Okay. Please great come at least this matter for admission after 3 weeks.
Please, Lordship, I'd like to mention items number 12. On behalf of in this case, Lordship, we have to file rejoinder. So, other two stand will be traffic to file our. And on the other side.
Okay. Mr. Singh, Lana Council, appearing on behalf of Mr. Tony Patti, Lana Council for the petitioner, raised for further 2 weeks' time to file rejoinder of an affidavit in reply to the affidavit filed by the filed by the respondent. Stop. Mr.
Itagbo.
Lana Council for the respondent is also present. Is grateful from 2 weeks, further 2 weeks' time is granted to the petition to enable him to file affidavit in the class. So list this matter after 2 weeks. Okay.
May it please your Lordship. Your Lordship, I beg to mention item number 29 and 31. 30 is also connected with, these are fixed for hearing. Your Lordship, with the consent of the other side, I need to file a reply, so I need some time. So I pray for adjournment of this matter and be taken up because with the consent of the senior counsel appearing for the petitioner, may I pray that this matter be taken up on 30th of April.
You need to file reply.
I will reply.
Okay.
I am for the respondent number 4 and 5.
Okay, Mr. Senapati, Lana Council for the respondent number 4 and 5. Submitted, although the matter has been listed for hearing, you need to file with affidavit in.
Affidavit in reply.
Reply to what?
They have filed, we filed an application to which they filed an affidavit in opposition. To that, we need to file a reply. Certain new development has taken place in the matter.
So, okay, submitted, certain new development has taken place for which he need to file affidavit in reply. Therefore, he, with the consent of the Lana Council appearing on behalf of the petitioner, prays for listing this matter
On 30th of April,
on 38th. List this matter on 38th, 30,
4 April.
30th of April. In the meantime, the April for hearing.
Yeah.
In the
For
meantime, in the meantime, the you are for respondent only.
I am for the respondent 4 and
Okay.
5.
In the meantime, the council, the respondent number 4 and 5 is the may file their
You reply.
affidavit in reply. Okay.
Not-
Yeah, my lord. I beg to mention item number 5 on behalf of K. Laya for petitioner, my lord. With the consent from other side, kindly, all the pleadings are complete here, so kindly mathematics for hearing.
It has to be admitted.
Yes. My
Who
lord,
is for the other side?
I have already informed the other side.
Okay. Who list it again? When do you want to say?
After 3 weeks.
Because the matter
Okay.
is pending since 2021 and they stay operating in the matter. Therefore, the matter may be listed under admission hearing
Okay,
after.
Mr.
P. Harmony,
Planning Council. You are appearing on behalf of
K lawyer,
your lawyer. Raise for adjournment of the matter for 2 weeks,
3 weeks, my lord.
Hmm?
3 weeks.
3 weeks.
Yes.
Okay. With Mr. R. Koyu, Land Council for the petitioner.
Sole respondent. I am for the.
Oh, sorry, so respondent. Has no objection. Provided the date is fixed. When? Okay, is agreed upon by the parties, let this matter be listed on March 12th.
Uh,
12 would be tricky, huh? It's fine only.
my lord, there is an interim.
The interim order passed earlier shall continue till the next date of listing. Okay,
Deeply obliged.
till then.
May I please, your lordship, in item number 8, today's fixed for TCI and bail hearing, but TCI is not yet received. Kindly adjourn the matter and fix another date for TCI and bail hearing, lordship.
Okay. 8. Mr. G. Pokamani, counsel for the petitioner is present. Ms. L. Hage, Planet additional PP. Some stats that TC is still awaited and placed for some more time. Prayer allowed. List is prayed for, list this matter on
20 February,
28th February. Huh?
20 February.
20.
Yes, Lord.
It's not possible.
Then 23rd,
Okay, 23rd.
Abless.
Your Lordship, I beg to mention item number 27. I'm appearing on behalf of Deep Panging petitioner. I'm taking consent from the other side. Kindly, this matter may be fixed on 24 February.
You are appearing on behalf of
Deep Panging also.
Mr.
Sita Jo, appearing on behalf of Deep Panging.
Land Council appearing on behalf of Mr. D. Pangan, Land Council for the appellant with the consent of the Land Council for the respondent. Praise for listing this matter on
24 February.
Hmm?
24 February.
24. Okay, the prayer. Okay. Is prayed for, list this matter on 24th. Okay. The
My
prayer
lord.
is allowed, huh?
My children.
My lordship, I beg to mention item number 28. The conducting council is out of station.
Who is conducting council?
Arsenal. And
No
I-
objection.
No objection.
no objection. And my lordship, the matter be fixed on 16th of February with both the
Okay.
consent. 16 March.
Miss
March.
Land Council. The Mr. The conducting council is out of station, therefore pray for listing this matter on
16 March.
16 March with Mr.
I'm teaming, my lord. On behalf of, I'm the respondent number 1 and 2, my lord.
Okay, Land Council for the respondent number 1. There is no objection. They are allowed. List this matter on 16
16
March.
March.
Okay.
March.
Lordship, I beg to mention item number 11. Lordship, due to some health issue, the leading council is out of station. So, Lordship may give a fixed date.
Okay, why it has been listed for?
It's- it listed for call for TCR.
Hmm?
It has been received.
Yeah.
Lordship, it's a teacher already arrived, Lordship. This matter may be, the registry will be directed for Lordship, preparation of paper book, Lordship.
There is probably, by the respondent also.
Yes, probably,
Not
yeah,
taken
yes,
a step.
responded, yes, Lordship. Informant.
Hmm. You take steps,
Yes,
Mr.
T Tayum.
and the counsel for the appellant. Some steps inadvertently, we could not take steps upon the respondent. Therefore, pray for taking steps upon the respondent. Number 2. Okay, prayer aloud. State upon the respondent, number 2, be taken by speed post as well as by usual process within a week from today, staff. In the meantime, the trial court record has also been received, staff. The registry is directed to prepare a paper book and list it after 5 weeks. Okay,
That's your.
Item number 1.
Yeah, my lord. And bill application under section 483 of the NS 2016, granting bail for arrest active person K. Samdong Verma, who has been arrested by Baligan police on that 23/10/2025 in connection with matter Baligan PS case number 29, 25 under section 23, 25 and 29 of NCF, and he presently in judicial custody since 23/10/2025 till that June 1, 2025.
the bail was rejected.
Yes, my lord.
When?
Uh, uh,
And recently,
2010,
why it was rejected?
due to commercial quantity of
Okay. Mhm. The bail was rejected on merit after hearing the party or on perusal of the record. What is the new ground that you have taken this time? Hmm? Hmm? What is the new ground you have taken? What was the earlier ground? And what is the new ground?
The applicant,
What changes has taken place in the meantime?
Your Honor, as from the case diary also, we come to know that even the investigation has finished and charge sheet has been filed. But it is pending before the DSP, Your Honor, for approval. And moreover, Your Honor, here, section 42, 50 and 52 of 57 and 57 of NSPS Act has not been followed, you know, which is a mandatory.
Are you also involved in some other case connected or similar cases or criminal antecedent? Have you stated regarding the criminal antecedent of
Yes, Your Honor.
the it is accused?
Yes, Your Honor.
Where? Which paragraph?
Paragraph 22, Your Honor. Page number 10.
What is this? So no bail application is pending. You have not stated criminal antecedent of the petitioner. And then see the investigation completed. There's not amount to to change of the situation.
Lordship, this page 8, para 18, it is reflected that the accused person is responsible person and law abiding, does not have any past criminal record. It is there, Lordship.
Okay. Okay.
Lordship,
So-
we call for the case study, Lordship.
See, on the same case there, it was rejected. Isn't it?
Lordship, because as he stated that the charge sheet is almost completed, so we have to go through, Lordship. If Lordship permits us, otherwise, Lordship, if there's no other new ground, then it seems to be rejected also, Lordship.
Heard, Mr.
Very well.
Learned counsel for the petitioner. Also had Ms. El Haji, learned additional PP for the state. Para. This is an application filed under section 483 of the BNSS 2023. Praying for grant of bail to the accused Samdam Brahma, alias Sundam Brahma, who has been arrested in connection with the Baligan PS case number 29/2025 under section 20C, 25 and 29 of NDPS Act. Staff. Call for the case study. May issue notice, call for the case study. Yes, when can, Balijan PS,
Yes, Lordship.
so when, next week?
Next week, Lordship.
Okay,
24, Lordship.
okay, list this matter again on 24th. Okay,
Apply. Lordship, 2 is also out of same FIR, Lordship.
similar order.
Yes, Lordship.
Hmm.
In order.
Item number 3,
Apply.
May I please, Lordship? Lordship, this is application file under section 483 of the BNSS, praying for enlargement of the accused person, whom Itanagar police woman was arrested in connection with Ita Women Police Station, 26/25. So, Lordships,
Okay,
may Lordship,
yes,
FIR Lordships, page number 25. Mary Lordships,
yes. Why? Yes.
to the officer in charge, Women Police Station, Bank Tinali, Itanagar, subject lodging an FIR regarding rape committed on 22 April
Okay, just wait.
2025. So, yes.
There is a name, you don't have to read, just wait.
Yes.
Okay,
Lordship, after
when he was arrested in connection with this case,
Lordship, he was arrested on 24/4/2025, Lordships. Yes,
since then he is inside the custody.
custody. It has been more than 9 months. He is languishing in the jail, Julie.
What happened to the case submitted into charge sheet?
Yes, Lordship, here in this case, charge sheet has already been submitted, Lordship, by the IO. And thereafter, charge
Charge
sheet
sheet under which
under section 64,
section?
60,
Fine.
Lordship,
Where is the last operative portion of the, have you annexed charge sheet?
yes, Lordships.
Where is the operative portion?
Lordship, it is at page number 137. Charge sheet framed by the Honorable Session Court, Lordships.
Charge frame?
Yes, charge has
Okay.
already been framed, Lordships.
136.
137, Lordships.
37.
Yes.
Okay, 64.
Yes, Lordships. May I read, Lordships?
09. Okay, robbery also,
Sorry, please, Lordship.
robbery also,
Robbery also, yes, Lordships.
and concealment also.
Yes, Lordship.
Hmm. So what happened thereafter? Any evidence recorded?
Evidence, Lordship,
Prosecution witnesses examined?
at this, as of now, at this stage, evidence stage, Lordships.
How many witnesses have already been?
There are, Lordships,
Examined.
9 witnesses.
Hmm?
9 witnesses.
9
as per-
witnesses already recorded.
Not recorded, yes.
How many recorded?
Still, there is, I mean, no witness has already been, no witness is recorded, still that. Now, next date is fixed on,
Okay, okay. Your bail application rejected. How many
Yes.
times? How many times?
Lordship, 3 times, Lordships.
Okay.
First bail application was, Lordship, rejected on 29/7/2025. Lordship, at page number 139 to 140, Lordship.
Victim not yet examined.
Not yet examined, Lordships. And Lordships, after rejection of the bail order dated 29/7/2025, thereafter, examination of the witnesses was fixed on uh, get 130 and 140.
Victim is 18 years old, vulnerable witness, and yet to be examined. Trouble.
Yes, Lordship, after rejection of the first bail application, Lordship, thereafter, matter was fixed for examination of the witnesses, victim.
What happened?
Thereafter, on that day, examination of the victim was not done, Lordships.
Hmm.
And again, after 1 month, more than 1 month, after completion of 1 month, then again I have filed one bail application, another bail applications. And there
Now
also,
see, the court has also observed
yes, Lordships.
on 2 bail application probably that the victim is a vulnerable witness. She is yet to be examined, and there is a possibility of your influencing. So what situation has changed thereafter? The same observation has been made.
Yes.
You can wait
My lord,
till the examination of the victim, because this is the reason they have given.
my lord,
Victim has not yet been examined.
yes, Lordship.
Then
But my lord, my humble
that
submission
cannot
is,
be ground, but since this observation has been made repeatedly, twice.
Lordship, my humble submission is, Lordship, after going through the each and every pages of the charge sheet also, it appears that even if it is accepted as presumed to be correct, there is a, Lordships, consensual act, Lordship, between the parties, Lordships.
What that?
After going through the each and every pages of the charge sheet, Lordships, especially in MLC reports, the statement of the victims and the statement of the victims under section 180 and 183, there is a contradictory. So my humble submission is, Lordship, even if
it is presumed to be correct, but then there is consensual act.
See the
So
report,
far as-
doctor's report? How that can be consensus? Medical report, have you seen?
Yes, Lordship.
Hmm,
Lordship may kindly come
that
to
cannot happen.
76 Lordships. Here, here a victim statement is Lordships. Victim statement is here Lordships.
Okay, so, yes, what to,
Yes, my lord, at most, my lord, this is a regular bail. My lord may call for the record, my lord.
to call for the record? On the rejected on the same ground. So when the next date is fixed, you said,
17/3/2026 Lordships.
7 and 3?
Yes, Lordship.
And otherwise also, my lord, after recording of the victim statement, they can approach the trial court.
Yes.
That will be better because trial court
That
is in
will
a
be
better
better.
position
Hmm,
to whether his custody would be required or not, whether there is a possibility of
hmm.
tampering or influencing the witness.
In a case of your rejection, you can come, always come. But then the court has clearly indicated that she is a vulnerable witness. She need to be examined first under the circumstances.
But my lord, the presumption of innocence.
Or
is
what, even if
privilege
we
of
call
every
the
accused person.
record before our
Yes,
examination also.
everything will be same only.
all
They have
same.
annexed all the records, my lord.
Mhm. It will be all the same. We'll give liberty, you file before the trial court after examination, immediately after examination of the victim, if nothing reveals, if you say that there was a consensus.
My lord may call for case diary. I will
What
try to
changes
convince, I will
see,
try to convince this court Lordships on next day. Okay.
What is the point for convincing? I'm not convinced. The same point, how it can be convinced?
Lordship, the rejection ground should not be solely on that ground, Lordship. There
That
are
is true,
so many
that is
grounds.
true, but then here the case where the observation made and then based on the statement recorded by the IO, the statement of the victim, medical report, and her age also not much, 18.
Even
That is what this observation has been made.
Even in this case, Lordship, surprisingly, the police has not furnished arrest memo also, Lordships. Arrest memo, Lordships.
That may be
Since
different
it is
ground.
mandated, yes.
Have you taken this ground?
Yes, I have
Is it your
taken it.
pleaded case?
Yes, yes.
Where have you stated?
Lordship may kindly come to page number 9, Lordships. C.
Hmm.
Yes, Lordships. May I read, Lordships? Accused was arrested by Itanagar Police on the 24/4/2025 from the bottom village near the football ground, not from the WPS Itanagar indicated in the arrest memo. And this effort investigating officer of the case measurably failed to serve the copy of ground of arrest in written form to the accused person at the time of arrest as mandated under the settled procedure of law. Such non-compliance not only reflect the serious
Call for the
procedural
record.
error.
We'll fix on it on say 16, 17 March.
Yes, my lord. If it is only on that count, my lord, then CD will be required. Because they are taking the plea of the ground of arrest,
Mhm.
the non-punishing of ground of arrest. But so far as the other,
But then charge it already filed.
yes, my lord, but
Will they? Will
because,
they have a-
my lord, the contemporaneous record has to be maintained in the case diary, my lord.
Mhm.
At this stage, my lord may call for the TCR. If it is not made as a part of the record, then again we'll call for, my lord may call for the case diary.
Yes, sir. Hard, Mr.
T. Dada Lordship.
Learning counsel for the petitioner. Also hard, Mr. PFF, learning additional people. So in the stage, responded. Let me the light. By filing this application under section 483 of the VNSS, the petitioner prays for the release of the accused, Sri Dulal Hussain, who has been arrested in connection with the, which PS? With another woman PS. Yes.
Itanagar Moment Police Station.
Number 26/2025, under section 64(1), 3094 of the VNS. Issue notice. Call for the scanned copy of the trial court record. Then when?
Six lordship, all 6 months. And my lord, let them annex the arrest memo also, my lord. Arrest memo is not the part of the record. Although they have taken the ground, it has to be substantiated by the arrest memo.
If you have taken that, you have to annex. That probably is not annexed. List of stationery. No, this is, no, this is examination report. only.
The Caesar memo is there, my lord.
Hmm,
The prima facie satisfaction, my lord, the arrest memo must be annexed, my lord.
it's not there. Have you taken this ground before the trial court?
No lordships, this is new ground lordships.
Then it doesn't look like that you have made this prayer or filed this application on that ground, because we have not even annexed
Lordship,
the arrest memo.
my lord. I have not found in the charge sheet, that's why. For my lord, prima facie satisfaction, they have to show it from the record itself, my lord.
Yeah.
If FIR is not there, they are directly hitting the non-violence compliance of Article 22, my lord. For that, at least prima facie material must be there, my lord. Mere statement will not suffice, my lord. So far as merit is concerned, my lord, at this stage, 164, that is corresponding to 182 of BNSS is there, my lord. The clear prima facie case is there.
Yes, that is.
So far as merit is concerned.
But what he is stating is from the statement of the others, because the victim was a victim also, known person. They were known to each other.
Yes, my lord.
Yes. Not the first time.
Yes, my lord, but whether this is the stage to
That is there.
consider this aspect, my lord. A victim, the sexual offense victim has stated clearly that she was subjected to rape, my lord. Clearly in the FIR 180 and subsequent 184 statement, my lord. So for the consideration of bail at this stage, my lord has to consider the prima facie allegation, my lord, and the material so far as collected during the course of investigation. The other aspect is a matter of trial, my lord.
Okay, in the meantime. So only that probably will be on record. The arrest
my lord,
memo
but
also.
Yes, my lord. For prima facie satisfaction, my lord.
He need to. It appears that he was not prepared for that.
Yes, otherwise, my lord, he let them file an additional affidavit. Let arrest me, my lord. Otherwise, the mere statement taking just that ground, my lord, prima facie satisfaction must be there by the court, and it is upon burden will be shipped on us to establish that ground was communicated, my lord.
If it is your pleaded case, you annex the arrest memo also, saying that there is nothing. You could not say. How do you know that the ground is not being communicated to you? From where?
Lordship, I talked to the accused persons.
So, what are you saying? Talk to the accused person.
I mean,
There is no arrest memo.
no, ma'am.
It is difficult. There's a basic one if you are claiming that on that ground. Mr. Town Council for the petitioner. Some is that he has also. He is also seeking bail on the ground that the ground for arrest of the accused was not communicated to him. However, some is that inadvertently the arrest memo of the accused person has not been annexed and praised for some time. Praised for allowing him to file the same, bring on record the same by way of filing additional affidavit, prayer allowed. List is matter on 17th. It will say 18th.
Yes, okay, man.
Okay.
Oblige, man. Oblige, Lordship.
Item number 4.
Mayor Lordship.
Yes.
Lordship, this is a joint petition filed by the petitioner for quashing out an FIR dated 21/2022, which has been registered at SEPA PS case number 02 of 22 under section 419, 467 and 471. Lordship, basically here, the petitioner number 1, who is the complainant, has lodged an FIR against petitioner number 2, alleging that the petitioner number has forced her signature and forced the minute of the meeting in recommending his father as a Gambura of his village. But Lordship, during course of trial, from the investigation, from the charge sheet, we can see the Lordship.
Investigated charge of charge sheet file,
Yes, file.
charge framed.
Frame.
Okay, then
Lordship, from the
trial began.
trial has begun, Lordship.
Okay. Witnesses examined already?
Not yet, Lordship.
Okay, charge framed.
Charge frame.
Under
Section 419, 467, 471. That is on Lordship, the charge frame is on page 55.
497?
419, 468, 471 of IPC.
494, 64, 7. Okay. IPC.
So Lordship, here the complainant petitioner number 1 doesn't want to pursue this case any further. And as such, Lordship, they have
Okay.
executed a deed of amicable settlement.
Okay.
Basically, Lordship, in this case also, if you go through the merit of the case also. The
Okay,
allegation-
who is this informant is the party? Who is this informant?
information is petitioner number 1.
Petitioner number 1.
Yes, Lordship. There is FIR is on page 15, Lordship.
Okay. And then petitioner number 2 is accused.
Accused.
Her allegation is that her signature was forced
Yes, Lordship.
by the accused
Yes, Lordship.
for
Recommend for appointing his father as an Gambura of
whose
the-
father?
that petitioner number 2, the accused father. So he has forced her
Okay,
signature
okay.
for recommending
Okay,
her.
okay.
his
She
father-
said that she did not sign.
Yes, Lordship.
Okay. Then what were the consequences, by the way?
Lordship, from the record, it says, Lordship, the recommendation was never used, that he was appointed by the deputy commissioner. As of today also, he's still serving as the Gambura. He's holding that post.
Okay,
So
so
Lordship, that has.
so according to the petition, according to the complainant, it was recommended based on the forced signature
Yes,
use.
Lordship.
Okay. Then what to do?
My lord, getting an appointment by a forged document,
That is,
this need to be, my lord, the recommendation by the member of the village, wherein, my lord, his father is alleged to be using that document and getting the appointment. The appointment order is also there, and he's still serving as a Gambura, my lord. So whether it's an offense against that individual, no, it's against the entire village, my
that
lord.
is why.
So getting an illegal appointment, my lord.
So subsequently, he was appointed as Gambura. When?
Lordship, he was appointed in the year 2021 and the complaint was made in year 2022. And Lordship, even if assuming.
Okay, the forgery was made, when this minute was prepared,
Minute was prepared, that is in.
July 21,
July 21.
and then he was appointed on,
He was appointed on
let us see.
26 November 2021.
21. See, after that only,
After the,
then it becomes the questionable.
Lordship, assuming for a moment also, if I had forged also, Lordship, it's the duty, the deputy commissioner also, they had given a complaint.
No. So the villagers,
Yes, Lordship.
they based on the recommendation or the agreement of the villagers,
Yes, Lord.
probably these Gamburas are being appointed. And then on the, if the villager did not agree with the appointment of the present, the accused for appointment as a GB,
Yes.
but then he has submitted a forged document that stating that the villagers has recommended his
Yes.
name. And on the basis of that, if the deputy commissioner is appointed, then the entire villagers are aggrieved.
That's what Lordship I have given in special abandonment in my petition also, that his recommendation was.
Okay, we'll see the record then.
Yes, Lord.
We'll see what they have
Yes.
stated. Okay.
And Lordship, since this is a joint petition, the petitioner number also doesn't want to pursue the matter because this has happened.
Maybe. But then you see the appointment itself is, had it not been the appointment for some criminal act, different. It's not a private again.
Yes.
Because he is appointed as a public servant. He has been appointed as a judge of the village.
Yes, civil
becomes
court judge, my
difficult.
lord.
That becomes
Lordship, that's why
difficult.
we have to say, if that is at all illegal, Lordship, it's Deputy Commissioner also will make an observation.
No. So Deputy Commissioner, you have say that the village, see the signature of the villagers, they have recommended me. And it's there, they have elected me or selected me.
Yes, Lord.
Then what is, see, the Deputy Commissioner has no reason to disbelieve you. If you saw this minute, see minute so many signatures.
Yes,
it
minute.
appears.
And Lordship,
Mm.
that's why Lordship.
And it had GB, if these are forged, then it will be a difficult. Okay. So, had Mr. Jam, Lani Council for that. Petitioner also had Mr. Ete, Lani additional PP for the respondent. This application under section 5 to 8 of the BNSS has been filed jointly by the informant and the accused in SEPA PS case number 08-2022, 22. Seeking passing of the GR case number 14-2022 arising out of SEPA PS case number 08-2022 under section 419, 468, 471 IPC staff call for. Now issue notice, since Mr. Ete appear and accepted notice on behalf of the sole state respondent, no formal notice need be issued. Call for the trial court, scanned copy of the trial court record. Staff, list is matter after
2 weeks, madam.
2 weeks.
Lordship, I have an interim in this matter that since Lordship.
Wait. No problem. Because,
Lordship, if since no prosecution witness has been taken up till date, only the next date is for prosecution which
charge frame,
charge frame, Lordship.
when is the next date?
It's on 18, Lordship,
18.
of February.
Let us see. Let him give 18 February.
Yes, ma'am. Lordship, since
18 is,
I have given in my mutual, deed of mutual also, since the petitioner number doesn't want to pursue the case any further. Lordship.
maybe. Let us see once. Who else has stated what? Because this is based on the forged document you have been appointed.
Yes, Lord.
If that is not the case, you don't have to worry. And then here,
In that,
after his 18 is day after tomorrow. When?
after,
See, day after tomorrow. It won't help you also. Let him state. And then from his statement also, it will be clear that there's nothing, no point going ahead. We'll say, okay,
Lordship,
he is
the
with you.
basic
He is with you. You don't have to worry.
is with me. That's why, Lordship, we have come before this honorable court on a mutual legal settlement. Otherwise, Lordship, that in that case also, if there is in the Lordship charge sheet also, there is nothing stated like.
No,
Whether I have-
no,
whether
here in this
signature
case,
on-
here in this case, we would like to see what he states.
Yes, madam.
Okay.
Obliged.
Lordship, in that only just an, I'm seeking an interim Lordship, till then, we can.
The interim order will be considered on the next date. Interim prayer shall be considered on the next date. Okay.
Obliged.
Item number 6.
Lordship,
Yes.
this is a question petition, where actually allegation is regarding the criminal trespass, and it's punishable only 3 months. But the fact of the case is that there is a land being run by one Nefa Audio, proprietor lives there in Haryana. And meanwhile, it's a boundary in between Arunachal and Assam that's in nearby Bandadeva, where it's means map is also there. It's there in Lordship, page number 35. So that the petitioner is a operator of the machine. And whereas that widening road, that boundary between Assam and Arunachal, in that widening road only, there was little bit of cutting of that, some part of that land, but there's no encroachment. And it's visible in this page number 35, Lordship.
Who appears for the,
Yes. So page number 35.
just a minute, who appears for the other side?
And
There is a private respondent also.
yes,
What happened?
yes, that
Service already been completed, Lordship.
Yes. And service has been taken, we had been serving the service to that respondent number 2 from 2024 onwards.
Now we call for record.
Lordship, records, Lordship, TCR has not.
Actually,
received yet.
charge sheet is also annexed over here, Lordship.
Hmm?
Charge sheet also annexed here, Lordship. It's charge sheet is there in page number,
What? Charge
38.
framed against the accused?
that's under 447, that criminal trespass,
Okay.
and 424, that mischief only.
Which one is non-compoundable?
That the 447 is, all are compoundable. Also, both section are.
Then,
That question here is that, Lordship, actually, the one manager who reside over there, it's a defunct sawmill. Nefa Udyog.
no, you said that it's a compoundable case.
Yes, Lordship,
Then why you
compoundable.
have come before this court.
Now, it's not a joint petition, Lordship.
Okay,
So,
maybe, but
Yes,
it's a compoundable.
yes, Lordship, compoundable, but the manager over there, that manager keep on changing, and the proprietor of that structure, that land, reside there in Haryana for last 30 years. And he manage and control over there. And meanwhile, there had been a Lok Adalat also. It's there in all, annex there. But that party, my humble submission is that since he is the operator of that machine only, and the road cutting was carried out based on the SADA project, government project, that the colony road.
Now, what happened to the trial?
Yes, in trial court from 2017 onwards till 2024, this petitioner, they were appearing before the trial court, but charge could not frame. Meanwhile, there had been a Lok Adalat held twice.
Why the charge could not be framed when the accused was present?
Yes, meanwhile, two accused died during this appearance stage only. There are 6 alleged accused.
Automatically, that will be
Yes.
vetted, and then whosoever is alive,
Yes,
against them, charge can be framed.
yes, that can be framed. But meanwhile, there was a medical issue. And subsequently, one more alleged accused has died during that period. Because the
How many accused are there?
6 accused, Lordship,
Okay,
and
three,
2
three died, okay, you
Yeah.
have killed 3?
No.
Then
2 died.
2,
Yes, and
Ah.
the person who, that the corporator who were running the SADA project under urban development, that the colony road is there, still exists, and there's no dispute, and there's no criminal trespass also. There's no case actually, Lordship. It's on record.
See, that is, if there is no case, if the case is not progress, you could have apprised before the trial court only.
Yes, yes, Lordship. If,
Charge frame, if there's nothing, nobody appear, discharge.
that's why, Lordship,
What-
still charge has not framed. So that's the Lordship man issue, because the person, the operator, he traveled
then-
from 70 kilometer away.
Charge not framed.
Yes,
Then what about have you seen the limitation, does it cover
Lordship?
limitation for,
Yes,
doesn't it cover in
yes.
this case?
Actually, if once that charge has been filed, it need to be framed within 60 days.
Then,
Then if that's
did-
not framed, then it need to be discharged, Lordship.
then
So
why don't you avail that?
that Lordship, before apprising, that subsequent date was fixed for the framing of the charge. So that's the area on
Let us-
record
let us
also,
see What, you have filed this application under
528.
5 to 8. Let us see
In-
5 to 8 first. Hmm?
PNSS, Lordship, inherent,
PNS system. Let us read together. Let us read.
Yes, Lordship, may I read?
Hmm.
Saving of inherent powers of High Court.
Hmm.
Nothing in this Sanhita shall be deemed to limit or affect the inherent powers of the High Court
Hmm.
to make such orders as may be necessary to give effect to any order under this Sanhita, or to prevent abuse of the process of any court, or otherwise to secure the ends of justice.
Where is the question of abusive processes come here?
Lordship, here the abuse of the process is that the person, the petitioner number one, is a operator of the machine. He has been hired by the department. Now the work is being carried out under the SADA project, and it's a CC pavement road. And there is no intention and objective to elements regarding this criminal trespass. Since that's a footpath, but while widening, there was no any fencing also. While widening, there was some cutting. But meanwhile, that manager made a fire. Subsequently, the proprietor lives there in Haryana, and he's native from Haryana only. And the person is from native of Assam, the manager. But the land is within the Arunachal Pradesh. But that mill was allotted by the government of Arunachal Pradesh to them to run a sawmill. But it's a defunct stage. There is no sawmill. And behind there is a village. And petition number 234, they are the villager. So that road is now being used by that villager only. And there was existing road just subject to the sanction of that project. And the project detail, that SADA project detail is also there. Report is also there in this petition. All those are annexed. So
What is the maximum punishment in the options?
it's a 3 months for 447. That's a cognizable. Otherwise, it's a non-cognizable case. And apart from that, there was a non-compliance of this BNSS section 41, means CRPC section 41A also. That's as they need to serve notice also. But meanwhile, they had asked them to come down and they arrested them. And meanwhile, this corporator has come down there. Now, corporator is also no more. The person who is the bailer for all those alleged accused.
See, if it is, the punishment is for 3 months.
Yes, Lordship.
When it goes, cross the limitation, cannot take cognizance. See, CRPC 468,
Yes, Lordship.
what is the correspondence?
It's a 514 in BNSS.
Yes. 514, see 514. Bar to taking cognizance. Can you read?
May Lordship.
Hmm.
Bar to taking cognizance after lapse of period of limitation.
Hmm.
1. Except as otherwise provided in this Sanhita, no court shall take cognizance of an offense of the category specified in subsection 2 after the expiry of the period of limitation.
After the
period-
expiry of period of limitation.
Yes,
Now,
Lord.
now let us see.
The period of limitation shall 6 months if the offense is punishable with fine only.
6 months.
Yes,
And yours is only 2 months.
yes, 3 months. Here, lordship, non-cognizable
But
section
it's
that's,
fine only. Okay, now come to B,
yes,
1 year.
yes. And here, lordship, here, read with that there is a mischief section 424.
Okay, what is the punishment?
That's a 7-year, lordship.
What are you saying? You just say.
No. Therefore, to take the cognizable offense is 447.
Hmm.
424 is non-cognizable offense. So here they had inserted 447 just to take the cognizance, and again they inserted 424. 424 is mischief.
So that punishment is 7 years.
Yes, lordship.
Then,
So here, lordship, it's a, if as per the record, lordship, if you, lordship may peruse that map and the report of this circle officer. That survey report that's in page number 23 to 24.
have we received the record?
No, Lordship,
Have we called for?
Lordship, registry may be directed to call for the TCR, Lordship. As per the record,
Whether the record was called for?
no, Lordship, not yet, Lordship.
Not called for. Then,
No, Lordship.
not yet called for. How do we decide that
Lord-
pending before the trial court without the record being produced?
Lordship, it's charge sheet is there in 38. I annex that charge sheet.
Maybe, but then we do not know what is the present status.
Lordship, the present status that it's
We believe you, but then we'd like to see the record. Heard Mr. P. Pippa, Land Council for the petitioner. Also heard Ms. Ulhage, Land Additional PP for the state staff. It is submitted that the trial court record would be necessary for proper adjudication of this petition. Staff, accordingly call for the scanned copy of the trial court record. Which court?
Chief Judicial Magistrate, UP, yeah?
Okay, pending before the chief, from the chief judicial magistrate, with the staff. List this matter immediately after receipt of the record.
Lordship.
Okay,
Applied.
Item number 7,
Lordship, here means there is additional affidavit, where means there in my means bail application, I had not declared that I'm involved in another case, where means I have been shown arrested, subsequently I had been released. But that has never been concealed. It's there in paragraph number 3 of that my bail application, where means I annex the bail order, where I had been this alleged accused has been granted bail by the learned court below.
where is the additional affidavit?
Additional affidavit,
Is there? Your file?
yes, Lordship.
Where? Last.
But as per previous order, just I need to apprise this my bail order.
Where is the? It should have placed. This year not yet received. State director, asking the scan, no. Where is the additional affidavit? Do you have the copy?
Yes, Lordship, I have.
When did you file? Not on record? Office not reflected?
Anyhow, Lordship, the bail order is annexed over there in my main petition. Previous, on last date, I could not apprise that part.
No, where is the additional affidavit? Have you received?
Yes, I have served.
Well, I have received.
Okay, it's not on record?
Uh, where means category.
When did you file? When did you file?
Actually, I filed on 13, but I that through this notary public and through registry.
This is not on record. Trial court record is there.
No, my
not
yet received, my
Okay.
yes.
Lordship, I'm in custody for last 157 days, and after charge sheet, it says 69 days after charge sheet. And based on same,
Charge sheet already filed.
yes, Lordship.
Okay, what is the offense?
Offense is under section 308, clause 2. That's punishable 7 years. And
What is this 308?
30 is
Corresponding to IPC?
correspondent, it's extortion, Lordship.
Okay.
And 1(3), that's section 13 of UAP Act. That's a 5 years punishment.
Okay, stay there.
And section 13 is not barred by law to grant bail by this honorable court, because it doesn't fall under section 43 clause D of this.
Yeah, I remember.
Yes,
You have stated that he is also involved in some other case. You have
Yes.
not stated, not
Yes.
annexed.
yes.
I think let that record be with
Lo-
the
Lo-
court.
Lordship, even though
Hmm.
since already the person who drafted that note, extortion note,
Hmm.
he has been granted bail based on this non-compliance of section 47 and 48. They had been arrested later on,
Who drafted what?
that the note, extortion note, Lordship.
Okay,
And I'm the person who has been asked whether this is a draft, who is the person. That's only my involvement is there. And I had been working because I'm an only single person in my family. And apart from that, my mother, widow mother is there. And
let the,
Lord,
your affidavit, the additional affidavit file be on record. Let that be on record, we'll consider. Okay, and at the same time, record also has, is yet to receive.
Yes.
But this case is fixed.
yes, Lord.
Yes, today's.
Then why the record hasn't come?
Because on previous first hearing on 30th of January, then the TCA was called, called from this special judge, special court.
Okay.
Subsequently, it's a magistrate tribal, then it was called from the JMFC UPA.
Okay.
So, Lordship,
Okay, it is with the,
all this alleged accused, they are on enlarged on bail.
the record is with the judicial magistrate first class.
Yes, madam.
Earlier, it was with,
It is only with judicial magistrate first class, my lord. But
Okay.
earlier mistakenly, my lord, requires call from session court, madam.
okay. The record would be necessary, huh? And at the same time, since there is also your statement, you has undertaken to file affidavit to additional affidavit
And that order is,
regarding his criminal antecedent with the record. So let that also be registered. Probably it has not yet been registered. There is in office note, it is not there, not yet reflected in the office note. The latest office note, not yet reflected. So let the record, along with the record, and then additional affidavit will take up. Okay, when the record can be,
what's available then, let.
SID case is with judicial magistrate first class.
My lord, this is JMC tribal, my lord.
Okay, the present one.
Yes.
SID case not under TC Act.
No, my lord, SIT, my lord.
It's Lordship, that section 13, this
Not under
UAP,
PC Act, my lord.
it's not under PC.
Section 13.
Okay, UAP.
UAP, yes, my lord.
Okay, okay.
And it's only 5 years only punishable, but my involvement is not much there.
Hmm.
So remaining there enlarged on bail, that's only Lordship. And I had been there in
But
custody for
then
last
for consideration,
157.
we would be
And-
requiring the record. Huh?
Their contention is, my lord, basically, my lord.
Then-
All accused person, my lord.
Hmm.
Enlarged on bail, non-compliance of the 47, 48 of the BNS.
Yes,
Okay,
That
not
is
on
there.
merit.
yes.
Not
And yours,
No,
That is
my
the-
one is also same because zone arrests, all are same, means arrest memo same. There is no ground of arrest. So that's only lordship.
Okay.
So-
We'll see the record then, record.
Even lordship, there is a
Okay.
getting up cases where honorable apex court has directed that if ground of arrest has not furnished, even the charge sheet is filed also.
We'll see, and if the ground of race has not been furnished, you will be entitled for bail. Okay. Mr. P. K. Pahlani, counsel for the petitioner, submits that as directed. So in terms of the order dated 5/2/2026, he has, although he has filed the additional affidavit, the same is not, he has already filed the additional affidavit. Bringing on record and bringing on record the criminal antecedent of the accused accused bail applicant. The applicant is the accused
No, it's a
Okay.
wife.
of the accused. However, the said additional affidavit so filed by the petitioner is not on record. Start. The registry will check the record and place along with this bail application. Stop. Mr. Kurdu Lanet, Special PP SIT is also present. The trial court record called for has not, and submits that the trial court record has called for has not yet been received. Stop. In view of the above, we should remind that for transmitting the trial court record, a scanned copy of the trial court record.
Yes, madam.
Stop. List this matter after receipt of the scanned copy of the trial court record.
Madam.
Okay.
Obliged.
Highly lordship.
Item number 9.
Lordship,
Yes.
this bail was supposed to be taken up for hearing today, but this morning itself, I have learned that the accused person, he was arrested in similar nature of case in previously. So I may be allowed to withdraw this application now, and then be abatement may be made in the subsequent filing also.
Miss. You are Miss
Diriba.
Diriba, the Lana counsel for the petitioner. Submits that this morning she learned that the accused is was also involved in similar nature of case earlier. However, the same has not been incorporated in the instant bail application. Therefore, she wants she prays for allowing her to withdraw this bail application with liberty to file afresh after making necessary correction. The prayer is allowed. This bail application is dismissed on withdrawn with liberty as prayed for. Mr. P.A.T.L. and some PP is also present.
Much obliged.
Hello, we have received the case, the reminder that may be reflected, CD may be returned. madam.
Okay, return the CD.
Obliged.
Item number 10.
Your Lordship, I'm appearing on behalf of the petitioners in the matter. This is a restoration petition, and we were directed to serve respond number 2. Your Lordship, the service report had to come today.
Service is not.
Not yet
completed, madam.
received.
Yes. It's awaited.
Service report not yet received. The record reveals. So what to do? When did you take steps?
Your Lordship, my local council took the steps, and we served
step
the
probably
respondent
has
on
to-
a new address.
The step was taken probably last year in the month of December only. So now
Yes, Your
probably,
Lordship.
it will be better if you can, if you take fresh steps. Since it is not returning, it's still awaited, it cannot be. You take fresh steps,
All right, Your Lordship.
a step was taken 1812, not yet received, probably. But then why it is not received? Okay. Miss Livina. Livina,
She's the local counsel, Your Lordship. I am
okay. Now
Advocate
you are-
Ishita.
You are Ishita, planning counsel for
Yes, Your
the
Lordship.
applicant. Submitted, although she has taken steps way back on 18/12/2025. However, the service, however, the notice upon the respondent number 3 is still awaited. In view of that, she prays for allowing her to take fresh steps upon the respondent. Respondent 2 and 3. Prayer allowed. Steps upon the private respondent number 2 and 3 by a speed post with AD as well as by usual process within a week from today. Stop. List this matter after 3 weeks. Okay,
Obligement.
okay. He's present.
Grateful,
Also,
Your
the record, huh? Mr. P. Delaney, additional PP is present on behalf of for state. Okay.
Item number 13.
Your Lordship, I on behalf of T. Torum, counsel for the petitioner. Your Lordship, many occasion step has been taken. Moreover, this morning, extra copy of petition has been served to the opponent counsel. So your Lordship,
You have taken a step only once,
that's,
and that is still awaited.
Your Lordship, today morning, I have served the extra petition copy to the opponent counsel by myself.
Okay, how many respondents are there?
There are your Lordship, 2 respondents.
Okay,
So your Lordship,
you are appearing on behalf of the state, private respondent.
Private respondent,
Okay, that's fine.
yes,
Have you received the copy?
today itself.
Okay, so
so your
what is your
letter may
submission?
be-
You want to file objection?
your Lordship, matter may fix after weeks for hearing.
In the meantime, you file your objection, if any.
Yes, Your Honor, maybe listed after 4 weeks because I need some more time because today I also received the copy
Okay,
and I also,
sir?
I know, Your Honor,
Your
my Lord,
Lordship, 4 weeks is too much.
okay. 4 weeks, but you are Mr.
Titay,
Itai, Lana counsel for the
petitioner.
petitioner. Mr.
this or
Who appear for the state? No, this or Lana counsel have you filed wakalat nama?
yes, today itself.
Okay. Would appear on behalf of the private respondent number 2 by filing wakalat nama and submits that he has just received a copy of the petition. And he needs some time to go through and to file objection if necessary. So on the prayer of the Lana counsel for the petition respondent. The respondent is granted 3 weeks time to file affidavit in opposition. List this matter after 3 weeks. Okay,
Highly
Much obliged.
just a minute, huh? Just a minute, huh? Whether record was called for here in this case. This is criminal revision.
criminal revision petition.
I think record is necessary. Whether record was called for, probably record. Issue notice. Await service. Record was not called for. Record is necessary.
Yes,
I think it's necessary. You are challenging the order of the court,
judgment of the court.
judgment.
Yes, from CGM court.
It's not from CJM, it's a session.
The main trial is on CGM. After that, they will session
Okay.
from here.
Revision. Okay. So where from the record need to be called for then?
CGM court, UPA.
It is available, the sessions order also available with CJM.
Because the case was in CGM court, and when they file one appeal before the session court, I think they may be rejected. And again, they file means criminal repression file against the rejection of the,
Okay.
yes,
It is submitted that the trial court record would be necessary in this case for proper adjudication. Accordingly called for the scanned copy of, not the scanned copy, then if it is disposed of, then we can call for the record itself. Call for the record from the session court in criminal appeal number 07/2025 and CJM code, what is the number?
private respondent.
What is the number in and it was a CR case. Hmm?
Yes, it was in criminal complaint case, CR case.
Okay. And CR case number 51/2021 from the Court of the Chief Judicial Magistrate India. Staff at least this matter after 3 weeks. Okay, Miss, then from before the presence of the respondent number 2, the presence of El Hage, additional PP is also present, huh? Okay.
Item number 14.
Yes.
My lord, please.
Mm.
My lord, respondent number 1 already filed affidavit in oppositions. However, service report to the respondent number 2, 3, and 4 are still awaiting. My lord, matter may be released after 3 weeks.
How many respondents are there?
3 are remaining, 2, 3, and 4. 4 respondent, my lord.
4 respondent.
Yes.
And you are 4?
Respondent number 1.
1. You have filed your affidavit in opposition.
Yes, Your Lordship.
Okay. And the service informative is 1. Okay. Hard Mr.
DBO.
Lana counsel for the petitioner. Also hard Mr.
Jet Manau.
Jed
Manau. No, I'm appearing on behalf of K. Taja.
Lana counsel appear now on behalf of Mr. K. Taja. Sorry. Appear on behalf of Mr. K. Taja, Lana counsel for the respondent number 1. So the notice upon the respondent number 2, 3, and 4 is still awaited. I think you have to take fresh steps upon these 2, 3, and 4. Because you had taken steps way back in the month of November. So now it cannot be. In still away, the service of notice upon the respondent number 2, 3, and 4. Awaited. That's one of my so. Okay. Just leave earlier one. A step was taken upon the respondent number 2, 3, and 4 as well. However, the same is still awaited. Taken on 2, 3, and 4 on 28/5/2025. However, the same is still has however, the return service has not yet received. In view of the above, the petitioner shall take fresh steps upon the respondent number 2, 3, and 4 by 2, 3, and 4. Step by way of speed post as well as by usual process within a week from today. List this matter after 3 weeks.
My lord, there is an interim order that may be continued.
There is an interim also.
Yes.
Okay. The interim order passed earlier shall continue till the next date of listing. Okay.
Item number 15.
My His Lordship,
Yes.
this is jail appeal, Lordship.
Hmm.
Legal aid counsel by the
Legal aid counsel
That's only judgment is there, Lordship.
appointed? No.
Not.
Okay. What is the offense about? It's a POCSO.
POCSO, Lordship.
Hmm.
Punishment up to 10 years, Lordship.
Okay. Mr. T. Lawyer, Leonard PP is present. None appears on behalf of the appellant. This jail appeal has been preferred against the judgment dated 15/7/2025 passed by the special judge POCSO Teju in session it was registered as a session case only. Case number 54 NMS 2016, whereby the accused has been convicted and sentenced to undergo rigorous imprisonment for 10 years with a fine of rupees 10,000 for the offense under Section 6 of the POCSO Act with deport stipulation. Start. There is no
There is a delay of 33 days, Lordship.
there is no
Bring it,
delay.
Lordship.
From the record, it appears that there has been a delay of it is noticed that there is a delay of 33 days in preferring the jail appeal. And just in view of the above, then considering that this appeal has been filed from jail, Miss, Mr. All legal aid counsel are lady. You body is there.
No,
Paramidam, sir. Division. Yeah, can Ginny is there? No.
no, is it Sulatya?
Hmm?
No, okay.
Okay. Mr. Gaken Ginny. From the, Gaken Ginny, empaneled legal aid counsel of the High Court is appointed as legal aid counsel to represent the appellant. And to file necessary and to file memo of appeal. Stock condemnation petitioner, condemnation application, etc. Stop, It appears that the trial court records has also been received. Stop, The registry shall furnish a copy of the records entitled to the appellant to enable the legal aid counsel to prepare necessary and prepare memo of appeal, stock, condemnation petition, etc. Then if necessary, start. Okay, list this matter after furnishing copy to the appointed legal aid counsel. Okay?
Yes. Item number 16. This is also jail appeal, Lordship. The offense is 376, Lordship. 376/511.
Similar order it appears. Similar order will be required. Okay.
Yes, yes, Lordship.
376. No?
Yes,
So how many delay there?
delay 31 days, Lord.
31 days. Similar order, and here Mr. Morik Bagra will do. Appoint Mr. Morik Bagra.
Deeply. Item number 17.
The judgment date will be different. Case number will be different. Court will be different. Yes.
My lords, I appear for the petitioner.
Yes.
The matter is listed today for arguments on the interim relief, my lords. This is the last order.
Okay.
Yes. My lords, I am Facebook India Online Services Private
Just a
Limited.
minute. Who is for the other side?
I put it
Respondent, how many respondents are there?
My lords, at the last hearing, all the 3 respondents were deleted, my lords. And
3
all the
respondents
others were-
deleted.
Yes, my lords, were struck off, order dated 19 December. And all the other respondents are, have been served and are appearing. my lords.
1912.
Yes, my lord.
Total, how many respondents?
8, my lords.
Out of 8, 4, 6, and 7 struck off.
Yes, my lords.
Okay. And then the rest are represented.
Yes, my lord.
3 or 4?
2 and 3.
2 and 3.
I'm informed that the respondent number one, counsel for the respondent number one, his leg on court number 2.
And then your 4?
I'm for 8, but let's count for 8.
8. And what about the one,
I am for respondent number 5.
you're for 5? 2, 3, 4, 5. 1, who represent 1?
One, Mr. Soki is appearing. However, he is on his legs at
Okay.
court number 2.
One is Just a minute, huh?
My lords,
Who filed this?
my lords, I appear for the petitioner, my lords, Facebook India Online Services.
Okay, just a minute, huh? How many? How many petitioners?
1.
Only 1. Let's go.
My lords, it's against an order by which my application for seeking deletion from the civil suit was rejected, my lords. It's ordered in, the impugned order is of 1st April to 2025, my lords. I filed an application seeking deletion on the ground that I'm not the correct entity, my lords.
Okay, who filed the
The suit is
Claim-
filed by respondent
suit?
1.
number 1?
Yes.
Then presence of respondent number 1 would be necessary.
My lords, may pass over if required, if he's,
Okay. Wait for some time.
please.
Item number 18.
May please, your lordships. This criminal petition has been filed asserting the impugned FIR laws against me, your lordships.
Just a minute, huh? 18.
My lord, before going into merit, case diary is required.
It's a criminal petition.
It's a criminal petition.
Passing of FIR lordship, then
It's
case
passing of
there is
FIR.
necessary lordship.
You are for respondent.
I'm for it.
You are contesting.
Yes,
File objection?
not yet.
Not yet. Would you like to file?
It's necessary, my lord.
Record was, whether record was called for?
Not called
Then-
record of.
Case there
Not
is
yet.
needed lordship.
Cease case diary, charge sheet has not been filed.
Investigation.
Still investigation. Charge sheet has not been filed.
No, not filed, my lord, not filed.
Not filed, okay. Then
Charge sheet has been filed, your lordships.
charge sheet filed?
No,
Okay,
it's still under investigation, your lordships.
okay. What is the offense involved?
It's a criminal breach of trust and cheating. And both are running simultaneously.
Okay, how many respondents are there?
Only the state and the informant, your lordships. I made a
Record
party.
was not yet called for. Sorry, case diary.
Never told me. Was never told.
Then the case diary would be necessary. Mr.
H board, your lordships.
Ms. Barua, Land Council for the petitioner. Also had Ms. El Hage, Land additional PP for the state respondent number 1. And Mr. K. Tari for respondent number 2. So it is submitted that the case diary would be necessary for proper consideration of the matter. Stop. According the code for the scanned copy of the case diary. List is matter.
After 2 weeks lordship. After 2 weeks
2 weeks.
lordship.
You also want to file?
Yes, if so advisable, I'll file.
Okay, also Mr. Tari, after Tari, huh? Who submitted? Yeah. Who pray for some time to file objection? Okay, then case diary, huh?
And
Call for the case diary. Scan copy of case diary. List is matter
after 2 weeks, I have no issues. Your Lord.
after 2 weeks. Okay.
But the thing is that interim, in view of the last order passed by the Honorable Court on dated 4/7/2025, there is this Honorable Court while issuing notices upon the respondent and also observed that the interim may be considered after appearance of the respondent number 2. So since the respondent number 2 has already been appeared,
Even for considering the interim also, you
Lordship.
would like, the case diary would be necessary.
Lordship, on the case, on the available on the case diary, the interim may be considered.
Automatically order will be passed on that day.
Lordships.
Okay. on which, okay, the interim prayer shall be considered on the next stage. Okay.
Lordship.
Item number 19.
My lord, in this case, the respondent, number 2 SDO, Duimuk Circle was directed to furnish report as this was matter of jurisdictional illegalities, whether the order passed by the SDO was done within his jurisdiction or not. That direction was given on the last date, and that today is date fixed for production. If they have received a copy, then that will submit.
Received that.
We'll receive the Friday, on Friday only, Lordship, sometime to go through and file.
No, my lord, whether if they admit whether this is done within their jurisdiction and that or not,
What
that this is to be decided.
What jurisdiction?
My lord, the petitioner has the land within RCA region, ICR region with a lot with LPC. The Duimuk Circle is a two different that is different division. So Duimuk SDO has passed an order to stop the development activities of the petitioner. That was the challenge before the honorable court was the Duimuk SDO has no jurisdiction to pass any such order is in the lack of jurisdiction. That was the main issue. So if they have received any paragraph comment whether they have done within the jurisdiction or illegal or legal, that will suffice.
Land Council for the petitioner. Mr. Loy, Land PP, some mistake, he has just received this is what? Record or paragraph?
Paragraph comment.
Paragraph comment. And need some time to go through the same and to file response if necessary. Okay, according need place for some time, prayer allowed, list this matter after 2 weeks.
My lord, earlier interim,
What interim?
if there was interim earlier interim order may continue,
Interim order saying what?
not to interrupt by the police authority to the petitioner's land.
But which order?
Order dated 29/1/2026. 29/1/2026. Oh, no, this is not the order. Pass order. Pass order.
It only says if. Okay, the interim order pass.
My lord, order dated 17/9/2025.
Till the next.
17/9.
Okay.
17/9/2025.
Item number 20.
Most obliged.
After 2021, 22. Okay, we take 5 minutes break, huh? That's.
Yeah, please.
Yes.
Lordship, as per last order dated, as per last order, as per the direction of this court, we have already served the service notice for steps of service for
Okay.
notice
Uh,
to the respondent party.
Mr.
T. Pavin.
Land Council for the petitioner is present. The notice upon the respondent number 2, AGLS 12 to the court is still awaited. In view of the above, let this matter listed after 2 weeks.
Lordship, it may be fixed after 4 weeks. If Lordship may please, it may be fixed after 4 weeks, Lordship.
Why?
There are some works going on from my senior, Lordship. My senior is engaged on some different occasions in these recent days
After 3 weeks. Huh?
of life, Lordship.
Item number 21.
Mayor, Lordship, Lordship, as per earlier order, we have served the notice to the respondent.
How many respondents are there?
Lordship, one, only one.
Okay. How many days of delay?
Lordship, 130, 135.
Mr.
T. Tayum.
Then counsel for the applicant. The office note dated 11/2/2026 reflect that the service of notice upon the respondent, sole respondent, has been duly served with and so the Chief Judicial Magistrate cum Civil Judge Senior Division, Pasighat. However, no one appears on behalf of the sole respondent. Staff, para. This is an application filed under section 5 of the Limitation Act 1963 for condemnation of delay of 135 days in preferring regular second appeal under section 100, read with section 42 of the Code of Civil Procedure against a judgment and decree dated 2/6/2025 passed in Civil Keba Appeal number 156/2023 passed by the Court of Civil Judge Senior Division. Start. The ground for delay in not preferring the connected appeal has been explained in paragraph which paragraph? Four, five.
5, Lordship.
4 and 5 of the condemnation application. Start. Upon perusal of the explanation given in the above paragraph, this court is satisfied that the applicant was prevented by a sufficient cause, prevented by a sufficient cause for not preferring the connected appeal within the stipulated time. Stop. Moreover, despite the receipt of the notice, the respondent is not appearing indicates that he has no objection to the condemnation of delay in preferring the connected appeal. Stop. In view of the above, this In view of the above, the delay of on 35 days in preferring the connected appeal is hereby allowed. With the above this, I stands allowed and disposed of. So, list the connected appeal for admission after 3 weeks. Okay.
Always. Item number 22.
May I, my lord?
Yes.
On the previous occasion, TCR was called, my lord. And maybe it's still awaited.
Okay. Okay. You are Mr.
P. Sri, my lord.
Land Council for the petitioner. He is present, Mr. Loy. Trial court record, have you received? Loy Land PP is also present. Trial court record is.
My lord, there's also an interim that may be continued.
In view of the above. Sorry. The registry shall issue reminder for the scanned copy of the trial court record. Stop. Till then, the interim order pass area shall continue till the next date of listing. Okay.
Item number 23.
There is a delay of 13 days. Let
Okay.
notice may go, Madam,
Okay.
in filing this RSA. Madam.
Okay. Heard Mr. P.P. Tara, Land Council for the applicant. Start on. This is an application filed under Section 5 of the Limitation Act 1963. Praying for condoning the delay of 13 days in filing the regular second appeal under Section 100 Order 42 of the Code of Civil Procedure against the appellate order dated 31/10/2025, passed in interlocutory application number 3/2024, entitled appeal number 02/2024. Start. Issue notice. The applicant shall take steps upon the respondent by speed post with AD scheduled by usual process within a week from today. List this matter after, we'll say 4 weeks.
Well, 3 weeks.
3 weeks. Okay.
I'm grateful.
No, 5 minutes. We'll take a break of 2 minutes. Yes.
Item number 25.
None request on behalf of the parties. Are you? 25, yes.
Yes, my lord, it listed for mediation, my lord.
Okay.
However, my lord, the respondent is still not entered appearance, my lord.
Oh.
So first service has to be completed. Then only it will be
Yes,
maybe sent for mediation, my lord.
Mm,
Perhaps service is not completed.
okay.
Otherwise, opens are compoundable, my lord.
Okay.
But the party respondent, the service is still not completed.
Wait. So how many respondents are there?
Only
Okay.
one, my lord,
Okay.
private respondent.
So for the petitioner is also not present.
Yes, my lord.
None appears on behalf of the petitioner on call. However, Mr. Piatelani, additional PP for the state is present. The record, the official note dated 13/2/2026 reflect that the service upon the private respondent number 2 is still awaited. In view of the above, list this matter again on after 3 weeks.
After 3 weeks, my lord.
Okay.
Obliged.
Matter number 26,
None appears on behalf of the party on court. Case standing ground. List this matter after 2 weeks.
matter number 17, Sapasava matter.
Well, that's the counsel for the respondent number one had said that I can start, he'll address the arguments at the next day. So my lords, if I have your permission, may I
Okay.
start? It's a small issue, my lords.
So what the counsel for the respondent number one says?
He's on his legs, my lords.
Okay.
Yeah.
Then what to do?
My lords, one small issue. My lords, I can pass on this notification
Okay.
to Delhi High Court, my lords. It's a circular by Delhi High Court.
Mm-hmm.
The issue in the underlying suit is, my lords, that there was some allegedly defamatory comments against respondent one on internet service on social media, including Facebook service, my lords, and the respondent number one had made Meta and Facebook India, which is the petitioner parties. Meta, which is respondent number 5 here, is already appearing, and I had filed an application under Order 1 stating that I don't control what is appearing on the platform. I am no longer required because respondent number 5 here and there Meta is already appearing, which is capable of complying with my lord's orders, if any, of taking down content from the platform. That's why I had filed my Order 1 application, which is rejected by order dated 1st April 2025, my lords. The learned court had noted that there is nothing on the record to show that only Meta is capable of taking down content from the platform. But I'll show from the records, my lords. But I just want to show this circular.
What is this circular?
My lords, the High Court has noted we were facing similar issues in Delhi High Court, where intermediaries, which are social media platforms, which are usually arrayed as defendants in suits, stating that they're not appearing and no effective orders can be passed. So, my lord, I note the circular has been issued by High Court of Delhi, saying that social media intermediaries who are regularly included in suits for passing of effective orders and their compliances are circulated for information. Here also only Meta is listed as an entity, my lord, not Facebook India, which is the petition. I'm saying, my lord, passes any order, Meta will comply. Any order for direction, Meta will comply. I'm an intermediary, my lord. I'm bound by the orders of the court. But Facebook India is not the correct entity, which is the petitioner here. My lord, may also note one order of Guwahati High Court, page 661 of the petition. Page 661. 461, my lord. Sorry. My lords, the fourth paragraph.
461.
Please, my lords. It's an order of Guwahati High Court
Hmm.
in a petition filed by Facebook India, which is the petitioner.
Hmm.
My lords, may have the third last paragraph. Without considering the fact that the petitioner resides outside of state of Assam, it is also submitted the petitioner
Right.
does not represent Facebook.
You're reading page
461, my lords.
461.
Please, my lords.
Just a minute. 461.
It's a 6th December 2022 order.
661. Oh, this is 461,
461.
not 661.
461, my lords.
Okay. So, para?
My lords, the fourth paragraph, without considering, it is also submitted that the petitioner does not represent Facebook India. It is submitted that Facebook India does not.
Wait, it is also submitted. Okay. Yes.
Further proceedings against petitioner is stayed until further order. A similar order was passed by Guwahati High Court staying proceeding against me because I was not the correct entity, my lords, because the correct entity is already appearing. My lords, one more Delhi High Court order. My lord, the counsel for the respondent number 1 is here.
Mm.
My lords may have this order, para number 3. Page 3, para number 3, my lords.
Yes.
Mr. Kapil Sibal, learned counsel, who appears on behalf of defendant number 9, Facebook Inc., and defendant number 10, Facebook India Online Services Private Limited, says that defendant number 10, oblique Facebook India Online Services Private Limited, may not be a necessary party, as the directions, if any, issued by the court will be complied by with defendant number 9, Facebook Inc. Now the name has changed from Facebook to Meta, so the correct entity is Meta Platform Sync, my lords, but it's the same submissions. Accordingly, defendant number 10, Facebook India, is deleted from the array of parties.
It says it will be complied with by defendant number 9, Facebook.
Inc, my lords. Today, respondent number 5 is already appearing, which is Meta Platform Sync. If my lords,
So
or
this Facebook Inc. and Meta.
Meta Platform Sync, my lords, now. It is renamed as Meta Platform Sync.
This Facebook Inc.
Please. And that's why in the circular by Delhi High Court, the name Meta Platform Sync appears, my lords.
Yes.
My lords, now my limited submission is, if the civil court tomorrow passes an order for taking down the allegedly defamatory content by respondent number 1, the entity which can comply with such order, I'm not being adversarial before this court or that court. I'm a performer entity, I'm an intermediary, my lords. All I'm saying is the correct entity for that purpose of for effective compliance of that order would be respondent number 5 here, which is Meta Platform Sync, and not with the petitioner. So, and my lords, I have annexed with my original order 1 rule 10 application a lot of judgments which say that Facebook India is not the correct entity as far as the content appearing online. In fact, my lords may have page 257 of my petition.
Two 57.
Please, my lords.
Yes.
Well, my lords, one of this thing. My apologies, my lord. It's 158. No, my lord. It's 157, my lord. 157.
Yes.
My lord, clause number 5.
Other.
Other. My lords, any user which, if tomorrow my lords are opening a Facebook account, they enter into an agreement whenever a user clicks onto that page. If I log in as a user of that platform, which is Facebook, I am agreeing to these terms of service. These are the terms of service given on my platform. These terms, formerly known as statements of rights and responsibilities, my lords, the serial number 1, my lords, have make up the entire agreement between you and Meta Platforms Inc. regarding your use of products. They supersede any other agreements. My lords, my terms itself say that Facebook India Online Services Private Limited is not the correct entity. It's Meta Platforms Inc. which is the correct entity, which is respondent number 5, which is appearing now in the petition as well as before the civil suit, my lords. My lords, there will be no benefit by making me a party or making me continue in the proceedings, my lords. My lords, do you want to, my lord, if I take my lords through the impugned order, the directions in the impugned order?
Page.
My lords, page 415 onwards. The main direction is on page 416, my lords.
4-1,
6, my lords.
okay.
My lords, the last paragraph, heard learned counsel, seen the application and the annexure. On perusal of the application, it appears defendant number 6 is engaged in online support services only, including marketing, technical and sales support in connection for Facebook in India. And in absence of any document showing exact nature of relationship between applicant, Facebook India and Meta, and related documents showing the legal liability of Facebook post published in India being only that Meta Platforms Inc. and not applicant, this court is of the considered opinion the presence of applicant before this court may be necessary in order to enable the court to effectively and completely adjudicate upon and settle all questions of involved in this suit. My lords, but I've showed, my lords, record from the application itself, which says Meta Platforms Inc. is the correct entity, not Facebook India. I'm merely a subsidiary which is concerned with online supports and technical and technical support and technical and marketing support. The correct entity is Meta Platforms Inc. My lords has the Delhi High Court circular. My lords has the order which says Facebook Inc. Since Facebook Inc. is appearing, Facebook India should be deleted from the array of parties. Perhaps these issues have previously also been dealt by other courts, and I'll take my lords through those orders. I'll just take my lords through the order. My lords, we have page My lords, we have page 204. My lords has state 204. It's an order dated 29 September 2015 by Delhi High Court.
Yes.
IA 372 of 2015, order 1, rule 10 by defendant number 5, which is Facebook India, which is the petitioner before my lords.
IA,
My lords, 204.
yes,
It's an order dated 29 September 2015.
yes,
My lords, on the bottom, it says IA number 372 of 2015.
yes,
The above mentioned application has been filed by defendant number 5, Facebook India on Private Limited, which is the petitioner here also, my lord. Under order 1, rule 10 CPC for deletion of its name. Learned senior counsel appearing on behalf of the applicant is pressing for disposal of the application. He submits defendant number 5 is not the necessary or proper party to the purpose of adjudication of the presence. He further submits the Facebook service in question is being controlled by defendant number 3 and 4, which is separate entity, my lords. And 5 does not control or own the servers that post content on the Facebook service. Thus, there is no rule of defendant number 5 to comply with the orders, nor the said defendant is responsible for posting the contents. In view of the amendments made in the application, as well as the reason that defendant number 5 does not own or operate any server, and it is not responsible for posting the contents that may appear on any website, the prayer made therein is allowed. Accordingly, name of defendant number 5 is deleted from the array of parties. My lord's next order. My lords, on page 206. A similar application was moved, my lords, before the Delhi High Court. It is stated by the applicant in its application that it does not control the servers that post Facebook service. Therefore, it will not be able to comply with any orders passed by the court in the main suit. It is also stated that the applicant has been incorporated to carry on business inter alia online support service, software development, providing technical support and services. It is further averred that Facebook service is operated and hosted by Facebook Inc. My lords had noted Facebook Inc. is now renamed as Meta Platforms Inc. A company incorporated and existing under laws of Delaware with its principal place of business in California and by Facebook Ireland, a company organized. My lords, it is further, I'll just come to the next page. It is further the case of applicant that prior to using Facebook service, a users enter into an agreement which provides the terms of use. My lords had gone through the terms of use, which clearly provide that Meta Platforms is the correct entity. A user enters into an agreement which provides the terms of use called the statements of rights and responsibility. And Facebook users in UK, Canada, including Indian users, enter into an agreement with Facebook India Ireland Limited when they when they register an account to use the Facebook service. Well, this is an old version of the order, but it's a similar case where Facebook India had passed this filed an application. The previously Facebook Ireland was responsible. Now Meta Platforms Inc. is responsible. And the similar orders have been passed, stating, I'll come to my lords, the relevant part. My lords, the relevant portion is 210, page 210. Further, even my lord, second paragraph from the top.
Yes.
Even after admission denial of plaintiff, defendant number 11, Facebook Inc., which is Meta Platforms Inc., my lords, has not disputed that it is not a proper party to the original suit. It was for the plaintiff to specifically plead as to how the defendant number 10 is necessarily a proper party to the suit, which plaintiff has failed to do so. In the facts and circumstances and view of aforesaid judgment cited on behalf of applicant, the applicant does not appear to be necessarily a proper party to the original suit. Accordingly, the caption IA is allowed, and the name of defendant number 10, which is Facebook India in the petition hearing, my lords, is deleted from the array of parties. Plaintiff is directed to file amended memo of parties within 2 days, and IA is accordingly disposed. My lords, there are judicial orders. My lords, there is a circular passed by a Delhi High Court, which clearly states that the correct entity for actually complying with my lord's orders is Meta Platforms Inc. and not the petitioner.
Now, the trial court observed that in absence of any document showing exact nature of.
My lords, I showed 2 documents to my lords. First
This is
is
court
the
order only.
my lords,
This is court order.
please, my lords,
Any document, do you have any document?
my lords, I showed 2 documents. These
Okay.
are the documents already on record. The document of statements of rights and responsibility at page, my lord, 157A. My lord, the 5th point from the bottom, 157, my lord, that's.
What is this document otherwise?
This document is the terms of service, my lords. It is annexed to the application, my lords.
Where it begins?
It's beginning at 149, my lords. Well, no, I think, my lords, yeah, my 149 one. On page 149, it says the Facebook company is now Meta. On top, my lords. Facebook company is now Meta. We've updated terms of use, data policy, and cookies reflects a new name on 4 January 2022. These are the terms of service for any users, my lord. And there, in page 157A, it clearly says these terms, formerly known as statements of rights and responsibility, make up the entire agreement between you and Meta Platforms Inc. regarding your use of products. There are judicial orders on record which clearly state that Meta Platforms Inc. is the correct entity. A judge has adjudicated upon this issue and passed an order.
Yes. Yes.
So my lords, all I'm requesting is If my lords wants to,
You are appeared as respondent number?
I'm appearing for the petitioner, my lords.
No, no, no. In the,
In the suit, my lords,
in the suit,
I'll. So defendant number 6, my lords,
6.
please.
Okay. Yes.
My lords, all I'm requesting is, if my lords are considering, my lords will stay the application of the order, because today people will misuse this order to say that Facebook India is also the correct entity. Which is not, my lords. I'm not adversarial to my lords, or any other court. All I'm saying is, for an effective compliance of orders by my lords or any other court, the correct entity is Meta Platforms.
And what is Facebook? Huh?
That's a separate entity, my lord. That does
Okay.
not govern the content on Facebook. It's incorporated for.
What it do then?
So,
what is that?
I'll take you to the AOA, my lords.
Hmm.
I just. My lords may have. Page. Page 160 onwards. Page 162, this is the memorandum of association of petitioner, which is Facebook India Online Services Private Limited. My lords, the main object of the company to be pursued by the company on its own incorporation. The first line, to carry on business in India abroad of online support services, consulting, conducting, designing, developing, dealing, innovating, programming, advertising, marketing, processing, procuring, providing, testing, storing, improving, importing, exporting, tracking, servicing, altering, improving, integrating, and otherwise deal in all types of online support services now. And online solutions in India or abroad, and to promote, market the product and technology, provide technical support and services. And merely a technical support and services, my lord. That's my limited role. My lord, none of the entities are saying that if tomorrow the civil suit passes any order against us, Meta Platforms will not comply. That is not the submission, my lord. In fact, Meta Platforms Inc., the correct defendant, will comply with that order. But my lords, defendant number 6 is not capable of complying with my lord's order. My lords can come to the prayer of the suit.
Prayer of the suit.
Please, my lords.
Hmm.
It's page. I'll just. Prayers of the suit. My lords, page 92. I have been arrayed as for a limited purpose, my lords.
Yes.
Well, the first prayer is not Kwame. The relevant prayer, Kwame, is prayer E. Pass a decree of perpetual and mandatory injunction directing the defendant number 5 and 6, its agents, representatives, in associates in conspiracy with others or otherwise, to suspend, block, and terminate the Facebook page of our TV and remove, delete all videos defamatory to the plaintiff and his family from the server. That's the limited prayer, Kwame, my lords.
So who
My
has the
role is-
capacity to comply with this prayer?
My lords, that is Meta Platforms Inc., which is
Yeah,
defendant number 5.
5.
Yes.
Okay, so
Defendant
your name included is 5 and 6.
Yes,
So you are agreed by this.
please, my lords. And defendant number 6 had specifically filed an application to that effect, which is rejected. I'm saying tomorrow.
6 file application for what?
Deletion from the array of parties.
Six, no, six, okay.
Yeah.
Now, 5 is appearing before the
Please, my lords.
trial court.
It's appearing before the court, my lords.
Here also,
Here also respondent number 5 is appearing.
okay.
And they have not said that they'll not take down if the court passes an order.
Okay. Yes.
So I may be deleted because I'm not the necessary party, my lord. That's my humble submission.
Okay. Yes. Good, yeah. Just let, okay, let us hear the respondent number 5.
Respondent number 5.
Hmm?
On behalf of number 5.
Okay.
If there is any past, my lord, that's the same.
Okay. So, what do you have to submit?
My lord, firstly, my lord, the issue, whether who will comply, what is the role of this Facebook India online service or Meta, my lord, that is a thing to be decided during the trial. That cannot be, my lord, today we are dealing with the constitutional jurisdiction that your lordship exercises under Article 227. Now today they have to, what is the power and powers under the 227, my lord? That is what I will submit on, my lord. This is today, my lord, your lordship is not sitting as a court of appeal, my lord. This is supervisory jurisdiction that your lordship is exercising.
Revision.
Yes, my lord. Now, my lord, they have to say how the learned trial court, my lord, failed to exercise the jurisdiction vested upon it, or there was an excess exercise of jurisdiction, my lord. The trial court on their application, my lord, after hearing the parties, my lord, came to a conclusion, my lord, they are being a necessary party or not. That is a subject matter of trial, my lord. They have to show where that is wrong, my lord. All these orders, my lord, these were all passed in civil suits, my lord, on the original side by the High Court of Delhi, my lord. Here the original jurisdiction, my lord, it's with the trial court, my lord, that is dealing with this issue, my lord. Whether who will comply or not, my lord. Even if they say they have no role to play, they have nothing to worry about, my lord. If they say 5 will comply, my lord, there is no cause for them to worry, my lord. And otherwise, they have to show how this order, the impugn order, my lord, of 1/4/2025, my lord, that is wrong, my lord. That is and wrong in as much that the supervised jurisdiction of this honorable court is required, my lord. That has to be shown, my lord. Today, my lord will not go into the facts, my lord. This is under Article 227. This is not an appeal, my lord, where the appreciation of evidence will be done. Evidence will be done, man. The lordship has to see where the order is wrong, whether there was an excess exercise of jurisdiction, or whether the learned trial court failed to exercise the jurisdiction vested with it, man. That is what we need to look into today, man.
This is a revision petition only.
This is under 227, yes, my lord. Whether all these things can be considered today, my lord. These are all matters of appreciation of evidence, my lord, they are coming with, man.
My lords, if I may.
Hmm.
My lords, I'm also told that the petitioner, the respondent number 1 and the main defendants in suit are also exploring the possibility of settlement between them. Then I will anyway no longer be required, my lords.
My lord, let that happen, my lord. Let that happen, my lord. If they say respondent number 5 will comply with the order, my lord, they have nothing to worry. And even if the settlement is being done, they have nothing to worry, my lord.
My lords, in the meantime, people will misuse this order.
Oh, my lord, that cannot be a ground, my lord. We cannot assume what will happen in the future, my lord. My lord cannot pass a blanket order saying that this will happen in the future, my lord.
My lords, I'm not saying that. My lords, I've showed from the record. In fact, I've showed how the terms itself, which were placed on my lords, the trial court's record, show that the actually agreement is between Meta Platform thing, which is the correct entity. There are judicial orders to that effect, my lords.
That is the fact only.
Those were, my lord, heard.
My lords, in fact, the circular itself says.
My lord,
That
those
it has
things
been-
were, those
Have you
things,
shown these, all these circular and
The
then the
circular
court
came-
order before the
came
trial
later, my
court?
lord. The circular came later in August 2025. my lord.
my lord, all those things were heard on the original side by the Honorable Delhi High Court, my lord, in a civil suit, my lord, exercising original jurisdiction. Those were based on the materials placed before it, my lord.
Now see, the 227, of course,
My lord,
limitation, and then unless there is a jurisdictional question, civil revision petition, whether lies there,
My lords,
how do you justify that the civil revision lies against the order where the trial court has exercised his?
my lords, it has, because
Mm.
I have shown, my lords, that the order itself failed to recognize that there were,
Where have you said that is excess of
please, my lords, I'll just
in your petition?
show, my lords.
jurisdictional error has to be done. firstly.
My lords, page from the petition. My lords, page 133. My lords, I'll just,
133.
my lords, that's the application, interim application. I'll just show, my lords.
No, no.
Civil revision petition, my lords, I understood, my lords.
In the civil revision or the revision petition, where have you shown that there is a jurisdictional error?
Please, my lords. My lords, para 27. Page 22. Petitioner respectfully submits that in exercise of its supervisory and divisional jurisdiction, this honorable court is duly empowered to set aside orders passed by lower court, such as impugned order, which suffers from material irregularity for non-considerations of material placed on record, or if there is any misdirection in law or in view of fact taken in the teeth of preponderance of evidence, or if the findings are perverse. My lords, then my lords, in para 28, the petitioner respectfully submits that the trial court fails to consider the material placed on record, which is plainly perverse and suffers from material irregularity. The impugned order is in the teeth of the preponderance of the evidence of petition. Indeed, the learned trial court failed to mention, let alone distinguish, the materials placed on record, including orders from various high courts, which categorically held that Facebook India is not the relevant data controller or for the Facebook service. Indeed, as also explained in the preceding ground, these materials ought to have been thoroughly examined by the trial court for determining whether petitioner qualified as a necessary or proper party to the suit. On account of the trial court's failure to do so, the impugned order suffers from material irregularity and deserves to be set aside by this honorable court in exercise of its supervisory and divisional jurisdiction.
Mhm.
My lords, in fact, the case law that I've cited on below on para 27, which is by Supreme Court, which is 2002-1 SCC 319. It is true that in I'm reading para 20 of the judgment, which is appearing on page 23 of the petition, my lords. It is true that in exercise of jurisdiction under 227 of the Constitutional, the High Court could go into the question of facts or look into the evidence if justice so requires it. If there is any misdirection in law or in view of fact taken in the teeth of preponderance of evidence, but the High Court should decline to exercise its jurisdiction under 227 to look into the fact in the absence of clear and cut down reasons where the question depends upon the appreciation of evidence. My lords, but the Supreme Court itself says that under the divisional power, my lords can look into the facts where it is required. My lords, para number 29 on page 24. The petitioner respectfully submits that the trial court failed to consider the orders issued by the various high courts, and the impugned order suffers from misreading of the evidence. The trial court not just omits to consider the
You are
development.
reading which paragraph?
Para 29 on page 24, my lords.
Mm.
My lords, has it?
Yes.
The petitioner respectfully submits that the trial court failed to consider the orders issued by the various high courts, and the impugned order suffers from misreading of the evidence. The trial court not just omits to consider the relevant clinching evidence provided by the petitioner, but also draws an inference from the facts which no reasonable person can arrive at. In the context, Honorable Supreme Court in Mohammad Inam versus Sanjay Kumar Singhal, 2027 SCC 327 at Paris 27 held as follows. No doubt that the observation in the aforesaid cases deal with revisional powers to be exercised by the High Court under special statute. Court has observed that in examining the legality and propriety of the order challenged in revision, which is required to be seen by the High Court, is whether it is in violation of any statutory provision or a binding precedent, or suffers from misreading of the evidence or omission to consider relevant clinching evidence, my lords, or where the inference drawn from the facts proved is such that no reasonable person could arrive on it or like. It has been held that if such finding is allowed to stand, it would be gross miscarriage of justice and is open to correction because it is not to be treated as finding of according to law.
Anyway, so
My lords,
so
my lords, all I'm requesting, if my lords, this circular has come later in time, my lords may remit the matter back to the trial court to consider
you
it
would
fresh.
have to examine in the context of the section 227. I don't think that we under the 227, and then that is also a revision, unless you show that there is a jurisdictional error, we would be able
My
to
lords, I showed. My lords,
interfere with.
my lords may give me one more date. I'll come with the case laws which help me.
Okay,
And
when can we fix?
a second,
In any case, today it will not be possible.
my lords
We
may,
need to confirm from the respondent number 5 also, yes.
yes, my lords.
Mm.
And my lords, 2nd March, if
Okay.
2nd March or 16th March, whenever convenient to my lords.
Oh,
Second month, 15 month. Any of the due.
so 16 or second.
My lord, on these dates, my lord, I might have some, because,
Okay, which
Yes.
day you are available then?
my lord, for me, it will be last part of the March, because, after this month, my lord, I have
Also,
the wedding
20
ceremony of
23,
my,
23?
no, my lord. After that, maybe in the last week, starting on 30, maybe,
Okay, 30.
My lords, is a Monday.
Monday, it's a Monday.
My lords may have it up higher up on the board if my lords allow.
Hmm?
Can it be on admission list?
Okay, it will be in admission now. Okay,
Order.
because hearing it will take a little long time. Okay. Hard miss,
Amira, my lord.
Amir, learning counsel for the applicant, for the petitioner.
Please, my lord.
Also had Mr. Sokipo,
I'm for R1, my lord, respondent 1.
respondent number 1. Mr. We can go for respondent number 2 and 3. And Mr.
And for respondent number 5. Emata.
Amate for respondent number 5 and Mr.
S count for respondent 8.
Let's count for respondent number 8. Okay, finish the whether the record was called for. Okay, the trial court record has also been received. Since
has
the
been called
parties
for.
are duly represented and the record has also been received, let this matter be listed. Let this matter be listed. Just a minute, when it is 30?
31.
Okay. For hearing, for admission, staff, as requested by the parties. Listed on 30 March. Okay.
All right. Not, may I please, Lordship?
Yes.
Lordship, I sincerely apologize and request this honorable court to mention some things on item number 20, Lordship.
Item?
20.
What happened?
I missed to mention, remind this interim order, Lordship. If interim order is there, kindly interim may be continued.
20 interim order passed earlier shall continue till the next date of this thing. Okay.
Deeply obliged, Lordship.
Yes.
Finish.
What about the 30? Okay, this is with 31.
Yes.